Now, Chief Justice of Nigeria, Olukayode Ariwoola, has retired after reaching the mandatory age of 70. His tenure was marked by controversies, including allegations of nepotism and corruption. The Human Rights Writers Association of Nigeria, HURIWA, criticized his leadership, citing the appointment of family members to key judicial positions, including his son, daughter-in-law, brother, and another family member. But despite the criticisms, Ariwoola listed his achievements, including the appointment of more judges, democratization of court administration, and the signing of new rules for the Supreme Court. Now, joining me to discuss this evening, we will be having Emmanuel Onwubiko, National Coordinator, HURIWA. He'll be joining us later. But then, for now, we have Jubrin Okutepa. He is an SAN and also a legal practitioner. Good evening, SAN. Thank you so much for joining me at this time.
Good evening, my sister. How are you? Good evening, Nigerians. Good evening, Africa.
Very well, thank you. Thank you for joining us. All right, so first of all, let's start with you telling us some of the challenges that are the primary challenges that you think is facing the administration of justice in Nigeria. What are the root causes of these challenges?
Well, thank you very much. As a man and as a legal practitioner who has been in and out of courts in all Nigerian courts, including our superior courts of records, the first challenge that one can notice in administration of justice in Nigeria is delay. Second is the newfound positions of our superior courts, particularly the Nigerian Supreme Court, in electoral jurisprudence, in returning us back to the old school of technicality that has completely overshadowed the determinations of electoral matters in Nigeria. So much so now that substance of electoral fraud, substance of malpractices that are brought to court via court orders, either by positive court orders or by what is in law called subpoena, are completely disregarded, and we are now clinging on to technicalities that for you to have your election petition determined, you must front load and file your witness statement on load along with your petitions within 21 days, including witness statements on oath of subpoena witnesses. Now, subpoena is one of the weapons that our founding fathers in the legal profession had invoked and evolved over the years for attainment of justice. It is a process where you command a witness not within your power, not within your reach, whom you cannot call, to get orders of court to call that witness. If that witness has in his custody evidence that are material to pleaded facts in your case. And so the Nigerian Supreme Court, with a profound respect to them, had decided now to take us back to what they said should not govern our electoral jurisprudence in the time past. So today, beginning from some cases and became more too pronounced under the 2023 election matters in
all right, while we're still talking about elections, I was actually going to ask you later on, but let me just, go ahead and do that now. Now, the Supreme Court has actually affirmed the re-election of Senator Duri as governor of Bayelsa State, and that's after dismissing the appeal of Timi Prie Silva in the November 11th, 2023 off-cycle elections. Now, what does this say about the lengthy process of, that's a lengthy judicial process?
I do not think that the process is lengthy. Given the amendment to our constitution by our lawmakers, and I must commend Parliament that have introduced considerable innovations in our electoral jurisprudence. By virtue of Section 285 of the Constitution, you have 180 days from the date of the declaration of the election results to file and conclude a trial of petition before the trial tribunal. Then you have 60 days from the date of the judgment of the Court of Appeal in the case of governorship and presidential for the Court of Appeal, in the case of governorship, for the Court of Appeal to decide the matter. And in the case of presidential election, under our laws, the Court of Appeal is the presidential court, and it has 180 days within which to determine presidential election petition. But appeal from presidential election to the Supreme Court then must be decided within 60 days from the date of the decisions of the Court of Appeal sitting as presidential election court. So the issue is not about the delay. I think we need to now begin to also tinker with our electoral processes by insisting that no one gets sworn in unless all petitions are determined. Because what we have seen from every indication, there appears to be an unwritten code that once you meander your way, either by hook or crook means, even the obvious and flagrant violation of electoral laws and guidelines and INEC rules and regulations, and you have the resources available at your disposal and you are declared, then by the principles of law that have been propounded by our courts, especially as affirmed by the highest court of the land, the Supreme Court, then effective roadblock mixed with concrete and made of iron has been effectively erected on the ways of those who have been cheated out of exercise of the votes the electorate are giving on to them. Because all you need to become anything in Nigeria as of today by the principles of law that you have seen is just to get yourself declared, either by hook or crook means.
Okay, I actually asked you that.
As good as being in the office, even when the sovereignty of the people was not in your favor.
All right, I actually asked that, because in most cases, leaders are sworn in, and then, the whole legal process, continues. And I'm asking that again because another senior advocate of Nigeria, Olukayode Ariwoola, suggested that elections should be held in Nigeria 1 year before swearing in, so as to, conclude all litigation concerning the elections and also to avoid any ambiguity. Now, what do you have to say about that?
I completely agree with my learned brother. That's profound, that is correct, because it is an open secret that even though the law prohibits it, those who have found their ways to power have considerably wielded some economic powers arising from the resources of the states and which they used or unaccounted for, and there are no consequences even after leaving office. You are all aware of people who have their days in contact with the penal law of the land, using all manner of manipulating processes, including filing frivolous processes to escape the penalty they richly deserve, and they are somewhere pulling strings. And so I think it is time for Nigeria to go back to the drawing board. First, no one to be sworn in until election petitions are determined. 2, pre-election matters will be abolished. Everything pertaining to election, including pre-election, should be rolled over. So the question and the distinction being made by our courts in saying that the allegation is pre-election, this is post-election, have become a tool of electoral fraud and injustice. For instance, a man who obviously has filed forged processes, forged documents, and used Nigerian system to get nominated, and then settle his political opponent, you are likely to have a leadership, a man of questionable character in terms of credentials. So we need to now begin to think and find solution that we are not being looked upon by civilized community of nations as people with civilized electoral justice. Because when we close our eyes to infractions that are visible to the blind under the added legal technicalities of jargon that you did not front-load a witness statement on oath, even when the evidence are before you.
All right, Mr. Okutepa.
I do not know how they sleep.
All right, Mr. Okutepa, thank you for that, what you just said. But then I'm being told that our other guest, Mr. Onwubiko, has actually joined us. Good evening, Mr. Onwubiko. Thank you for joining us at this time. All right. For those of you who are just joining us, Emmanuel Onwubiko is the national coordinator of HURIWA. Now, Mr. Onwubiko, you described Justice Ariwoola as one of the worst CJN ever. What is your reason for that, and what specific actions led you to accuse him of nepotism? Can you hear me? All right, I said HURIWA actually described Justice Ariwoola as one of the worst CJN ever. What is your reason for that description, and also what specific actions led you to accuse him of nepotism?
Well, the issue is that the immediate past CJN, the immediate past CJN didn't actually try so much to sanitize the judiciary, and he made it very, very crystal clear that he wasn't there as a a reformer, that he's just there to just occupy space and to maybe have that opportunity to kind of fix his people in very strategic places. He didn't. You can't actually point at any milestone. You cannot say this is what this CJN achieved, even in terms of instilling discipline and professionalism among judges. There's nothing that is very, very, very powerful that the NJC under him has done in their attempt to instill discipline, because there's a lot of corruption in the judicial system. Because it's even during his period that the United Nations Office on Drugs and Crime issued a report that the judiciary in Nigeria is much more corrupt than the police. And it's a very unfortunate something that you occupy an office, even if the office you're occupying is just for 6 months. You need to set up a legacy so that Nigerians will talk about you for a long period of time. But the CJN had just left, didn't even achieve that. He ended up, elevating nepotism as a practice in judicial appointment of judges, where he appointed his own son, appointed his brother, appointed that. It's not a very good image for the judiciary.
With the National Judicial Council regarding these accusations. Can you hear me? So I was asking if you, HURIWA, at any point engaged with the National Judicial Council regarding the accusations.
Council, we don't have any matter against the former Chief Justice of Nigeria, but we're just there. We've told Nigerians our mind, and that is the end of it. Because everybody who is in this country unless somebody who does not live in Nigeria knows that within this period that CJN, Ariwoola was in office, it was like jumping from one frying pan to fire. Every other week he has one controversy to his name. He started by making a lot of controversial statements where he was shown on TV sounding very partisan, trying to support Wike for sabotaging his party during the elections. Yeah, he was talking about the 5 governors of PDP that left, and he seemed to be praising the 5 governors on TV in a party that was organized for judges in Port Harcourt. It is very much unknown that judges ethically are not supposed to even attend a social gathering, but attend a social gathering and you begin to sound partisan as a CJN of the country is the lowest any country can accept. And then, as the chairman of NJC, he went out of his way to appoint his own son, biological son, as a judge of the Federal High Court. How much low can the judiciary go? It is very unfortunate.
If you can hear me, Mr. Onwubiko, now speaking about his appointment of his son and also family members, you had actually sought the nullification of his son as judge after he was accused of appointing family members to key judicial positions. Now, I actually want to know, how do you respond to critics, who say that your accusations are politically motivated?
Well, maybe those ones who say that opposition is politically motivated are not, maybe they didn't go to school. If you go to school and you actually go to school, you went to school and you read the English language, you understand the meaning of nepotism and conflict of interest. These things are legal issues. I'm not a lawyer, but we have a lot of lawyers in our association, the Human Rights Writers Association of Nigeria, HURIWA. So it's not a question of being politically motivated. Are we in any political party? We're not a part of any political party. What I'm saying is this, it is not ethical for me, as Emmanuel Onwubiko, for instance, if I'm the one in charge of NJC, for me to appoint my son, biological son, as a judge. It's not done anywhere in the world. It's nepotism. Nepotism is a crime, constitutionally. It's just that so many things happen in Nigeria, and when we raise such issues in the media, and maybe other people, even some NGOs even went to court to challenge it, and the matter was thrown overboard because of esprit de corps among the justices, among the judges. So we're not saying it because we're politically motivated or whatever. What is politically? Even if we're politically motivated and we're saying the correct things, does it really matter?
All right. Okay, now let's hear from Mr. Okutepa. Now, you've heard everything that Mr. Onwubiko has actually said, and there was something he said that, according to a report, that the judiciary in Nigeria is more corrupt than the police. I want to know your response to that, and also what measures can be taken to address the issues of nepotism and political influence in appointment of judges.
Well, there is a report making round, rating the Nigerian judiciary as the most corrupt institution, has not been effectively denied. And when we talk about corruption, I think we should not look at it from the point of view of either collecting money or taking physical money in bribery. When you bend justice or bend judgment to satisfy the whimsical interest of political godfathers that puts you in the position or lobby for your appointment, that itself is corruption. Now, justice is rooted in confidence. And mark you, when right-thinking members of the society go away, that indeed the judge must have been bribed, even if there is no bribery, once there is an appearance of impropriety in the conduct of a judicial officer or conduct of a justice, that must be avoided, because a judicial officer is not a politician, and the attribute of a judicial officer is impartiality. A judicial officer is not supposed to be found in a political rally. And so I think that answers your question. Second point you have asked is, what do we need to do to avoid all these things that we're talking about? I think we must go back to the good olden days. There is a lot of lobbying, a lot of political interferences. Who you know matters now more than what you know in appointment of judicial officers. And unless we eliminate that from the appointment process of our judicial officers, you are likely to have a worse situation than what you have now. And that's why I'm happy that the incoming Honorable, the Chief Justice of Nigeria, my Lord, Honorable Justice Kudirat, M.O. Kekereekun, has been a woman, a judicial officer of impeccable character. And so I think his Lordship has a very uphill task. The judiciary must be completely isolated from partisan politics. Partisan decisions that are being dished out now, that within the parameter of king does no wrong. The moment you smuggle yourself into power, even when you follow a wrong process and you cannot be removed, we must avoid it. Apart from one of the governors in the Southeast that was removed for Chris Ngige, for P2B, and then Hope Uzodinma replacing Emeka Eyedewa. You discover that even when Nigerians of all shades of opinion know that electoral processes that produce the so-called winners was fraught with malpractices of monumental proportion, we have clicked onto so many, sometimes technicalities to kill the popular will of the Nigerian people. And that's why there is no accountability in this country. So we must go back and recruit men and women of strong character, men who can say no to every form of manipulations, including manipulations from the power that be in the judiciary. Those who can say, no, I took oath of office and I'm not going to do what you're asking me to do. Those who give justice undiluted, not diluted justice, rooted in arid technicalities that is called technicalities at the expense of substantial justice. That has always been my crusade.
All right, Mr. Okutepa.
Secondly, those who are currently on the bench need to have character tests. They should give them examination. Those who are not reasonably fit to be on the bench should be withered away and giving way to those who know their onions.
All right, Barrister Okutepa, thank you for that. Now let's come back to Mr. Onwubiko. Mr. Onwubiko, if you can hear me. Now, for justice to be truly impartial, the judiciary must be free from undue influence and interference from other arms of government. Now, can you comment on the impact, of former Justice Ariwoola's tenure on the independence of the judiciary, and what role do you think politicians play in undermining the independence of the judiciary?
You can't have good governance in any. If I get your question well, you can't talk about good governance if the three arms of government are actually not independent. There's no separation of powers. These are the critical principles that the Constitution contains. If you have Section 4, Section 5, and Section 6 making specific provisions for the functions and the powers of each of those three arms of government, and now you have a situation where the three arms of government are actually not independent from each other, then we don't have good governance, we don't have constitutionalism, we don't have democracy. If democracy operates in a very seamless manner, when you have those three arms of government operate independently, we're not saying that there should be there should be constant squabbles between the three arms of government, but to have the three arms of government conspiring against the public good of the citizens of Nigeria, then it doesn't really make sense. That's what we're saying. That's what we're talking about.
How do you think that the political class can be held accountable for their actions and made to respect, the democratic process rather than seeking to manipulate it for their own gain? This is for you, Mr. Onwubiko. Mr. Onwubiko, can you hear me? Please, can you tell us, Mr. Onwubiko, how can the political class be held accountable for their actions and made to respect the democratic process?
There's a lot of noise at the background, so I'm not even hearing you properly.
All right, we'll come back to you. We'll come back to you, Mr. Onwubiko. Let's now move to Mr. Okutepa. If you can hear me, Mr. Okutepa, the same question actually goes to you. How do you think that the political class should be held accountable, rather than, allowing them manipulate or even seek justice for their own gain?
I think the answer lies in the boldness and courageous nature of the Nigerian judiciary. If the Nigerian judiciary decides to take sides with the Nigerian people and not taking sides with the political class and the executive, the politicians will be held accountable. You will recall in those days when removals of governors were just done at will, it took the boldness of the Supreme Court to nip that in the bud. And so if the Nigerian judiciary decides that, look, enough is enough, we will not hide under this technical jargon called sui generis to install an unqualified people or people who have not won election, allowing them to be addressed as Your Excellencies and honorables and so on and so forth. And elections are nullified. And an institution called Independent National Electoral Commission are held liable and accountable to the Nigerian people and held sacrosanct to its rules, then politicians will behave. What we lack is a strong leadership in the judiciary that is not depending on the executive for survival. The judiciary also must, as a matter of course, because when we return to a state of nature, where they fail their responsibility as bestowed on them under Section 6 of the Constitution of the Federal Republic of Nigeria, in resolving conflicts within the parameters of understanding of substantial justice, but begin to dish out to Nigerian people arid and colored justice that are not rooted in a civilized way of resolving conflict in a multi-society like Nigeria. Possibility exists of people bottling up, possibility exists of peace eluding that society. So I think that the survival of Nigerian democracy is on the Nigerian judiciary. Politicians are not people who think rationally. Politicians are not those who have a code of conduct rooted in morality and righteousness. Everything and just anything that is available to politicians, including immoral conduct, can be exploited to come to power. The only institutions that have code of conduct and well-defined training to put the judiciary, to put the politicians and even the legislative arm of government is the judiciary. And so we should allow Nigerians to ventilate their angers and grievances in our courts under a very pure and undiluted justice without sending us away by the manner they are doing. All manner of things that you see on the television, on social media, rigging of elections, people who didn't win have results written for them and announced by INEC. Nigerian judges are not foreigners. They are Nigerians in Nigerian soil. And it is their duty to bring Nigeria to the Committee of Nations of Civilized Adjudication. When we begin to bring in principles of law that put roadblock in adjudication, it is a recipe for anarchy. And when there is anarchy in Nigeria, I wonder where judicial officers will be. There are good judicial officers, no doubt, but the infinitesimal number that have responsibility to decide issues seems to be more inclined to retain the bad status quo that have brought us to where we are. There can be no development in any society where justice is colored and dished out only to those who have the means of production. So my submission, therefore, is that the judiciary hold the machinery, the weapon to hold the political class accountable, and they must distance themselves from it. Otherwise, when they go to Nigerian markets, like lawyers too have responsibility, because we all belong to this society called Nigeria. And it is our duty to make it work. And it must work. And if we want it to work, then the judiciary must be born again.
Briefly, you know, in your expert's opinion, how do you think Ariwoola's legacy will be remembered in the context of Nigerian judicial history?
Well, my answer is it will be remembered in the circumstances that Nigerians have been describing. So I do not have any express opinion to form. You know how it will be described. So, but that's now, in the annal of history, we have had previous Chief Justices of Nigeria that had held Nigeria and were no-nonsense judicial officers. Look at the manner of punishments dished out to those who have polluted the stream of justice, who are sitting as Judas in the temple of justice. Why should you say somebody who is not fit and proper to be on the bench should be put under probation? What is the meaning of that? The NJC must bite, not just back it, must bite. If a judgment turns the law upside down, that Judas either does not know law or he has been compromised. Whichever is the case, is not a fit and proper commodity to be on the bench. Because after all, we call those who are sitting on the bench, my lord. And it's not a joking title. It's a title that has its genesis and roots in almightiness. So they should be above board, like Caesar's wife. No judicial officer should have a purity of office contaminated by anything other than purity.
Thank you very much for that take. Let's hear from Mr. Onwubiko, if you can hear me. Would love to know how you... Okay. Oh, I'm told that we've actually lost Mr. Onwubiko. And I think with that, it's a wrap on this part or this section of the conversation. Thank you so much, SAN, for joining us. SAN Okutepa, thank you so much. Jubrin Okutepa, legal practitioner, for speaking to us on this. And in the absence of Mr. Onwubiko, would also love to thank him for joining us and speaking to us. He's the national coordinator, HURIWA. We appreciate you for your time.